Hello, everybody. Welcome to Chatting with Charlie, EB-5 Investor Outlook. Today is October 29th, 2024. Happy Halloween to everyone. It's great to be here. I, of course, am joined by Charlie Oppenheim, Director of Visa Consulting at WR Immigration. Charlie, great to see you and welcome back from your travels abroad.
Yes, it's a pleasure to be here today.
And my name is Joey Barnett. I am a partner at WR Immigration. I focus primarily in our EB-5 practice, and I've been doing this for 13 years. And today we're focusing on the EB-5 program. Of course, this does not constitute legal advice. It's just for information purposes, but we want to be your immigration attorney. We have a lot of demand for EB-5 right now, in particular, those inside of the United States who are on non-immigrant visa status and are looking at EB-5 as a backup option in case there are layoffs by their H-1B employer or by students in the United States who may be looking at that OPT time coming due and not having an H-1B sponsor. And so EB-5 is very, very big right now, and we are doing consultations every day with people inside the United States who are looking to seek down this path, and we would be happy to talk to you. You can always reach out to us, visalaw@wolfstorff.com. You can also email me directly at jbarnett@wolfstorff.com, or just go to our website, wolfstorff.com, and you can click and get a link to do a consultation with us. WR Immigration, we are a full-service immigration law firm. Our EB-5 practice is based out of our California, Los Angeles office. That's where I'm located, along with our managing partner, Bernard Wolfstorff, who is the past president of the big National American Immigration Lawyer Association. And our other partner, Farshad, was just the past president as well. We're very active in ALA, and we have a very big presence there. I currently serve as the vice chair on the EB-5 committee. And it's been a great role so far, and it's been nice because we get to talk with the Ombudsman's office about EB-5 problems. Earlier this month, I was in a meeting with USCIS headquarters, some of like the top district directors leading customer service with USCIS. We complained about the fact that you can't track your EB-5 case number through their My USCIS case status online, and they were unaware of that. I don't know how, but they were, and hopefully we'll be seeing some fixes on that at some point. But anyway, you can be sure that your WR immigration attorney is at the cutting edge in the practice, making sure that they're on the top of the trends and making sure that your EB-5 case can get approved and the green card issued. Today, we're going to be talking, as we always do, about the Visa Bulletin. You know, Charlie used to write the Visa Bulletin for decades when he worked at the Department of State, and now we have this great insight that really nobody else has. So it'll be great to speak with Charlie about his thoughts about the current November Visa Bulletin and, you know, what types of considerations we should be looking at, thinking about, hey, when will final action dates be imposed in these EB-5 reserve categories? What does that mean for me and my family planning and use of EAD and advanced parole? We're going to be talking all about that stuff today when we go over the concurrent adjustment opportunity. And then we're going to be talking just a little bit more about what the Department of State had recently told us. And we're going to finalize it with a further discussion from last month's Chatting with Charlie, where we got some updated data through a FOIA, and others in EB-5 have gotten more data since then from FOIA. So we have some more information about the demand for these reserve visa categories. And so we're going to be talking about demand versus supply and what does that mean for EB-5 investors, particularly Chinese and Indian nationals. With that, let's jump right into it. The Visa Bulletin, as you probably know, has a Chart A final action date and a Chart B date for filing for every employment-based preference category. And what we're looking at today is the EB-5 visa categories. There's 4 of them. And Charlie, were there any changes from October to November that we can discuss?
No, there have not been any changes in the dates, and I do not expect any forward movement of either the China or India unreserved dates before the second half of the year, maybe later. I believe that state advanced them sufficiently at the beginning for October so that they would not have to make any adjustments again until the second half of the year.
So you were expecting this November date to remain the same just based on what DOS wants to see in the demand that they want to create?
Yes, I was expecting it to hold based on what I would consider a drastic forward movement. If I had been doing something, I think I would have moved the dates in a slower, more incremental manner. Doing so minimizes the risk of potential retrogressions of dates later in the fiscal year. But for whatever reason, state decided to make such a drastic movement upfront, possibly to allow more cases to be processed earlier in the year if they were aware that there might be issues that would prevent processing later on in the year. So I'm assuming they had a very good reason for making the large movement.
Okay, that makes sense to me. And what about these reserve visas? They remain at current for Chart A and for Chart B, right?
Yes, the categories remain current. All three reserved categories are current. I think they will be for the foreseeable future.
And the big reason why you're saying you think they will be for the foreseeable future relates to this chart here and the number of reserve visas that are available for use in fiscal year 2025. Is that right?
Yes, right now, state is not processing cases enough until the amount of numbers being used will exceed the supply of numbers. There is absolutely no reason to impose a final action date. I think that the telltale sign if a date will be imposed is if state has a Chart B application filing date that they impose. They would do so to limit future filings. So again, I think the dates will stay current for the foreseeable future and pay attention to Chart B for any telltale signs.
Right. And the Department of State has also cautioned us to really take a look at the notes at the end of the Visa Bulletin too, right? Because they should at least give us some advance warning or some sort of notice that we may be seeing a final action date in the future too, right? I mean, at least that's a goal of theirs.
Yes, that is correct. I always tried to give at least 1 to 2 months warning anytime that I saw that there would be some type of potential adjustment in a date so that people would have plenty of time to make plans for future actions.
In the past 2 fiscal years, the Department of State has used all of the unreserved visa numbers, which is really great to see. Do you see anything or have you heard of anything that would change your mind on their use of the unreserved numbers in fiscal year 2025? Do you see any reason why they wouldn't be able to use all of those unreserved numbers?
No, with Guangzhou being back essentially up to full speed, there really is no reason why the total amount of unreserved numbers are not used this fiscal year. And again, an indication of that may be the drastic movement of the dates initially for October to allow more numbers to be used early in the year. This past year, we saw the number use, particularly for China, was very low through probably the first 6 to 8 months, with the bulk of the numbers seeming to be issued during the final quarter. So they may be trying to avoid that situation this year again by moving the dates earlier.
Well, I certainly hope so. And we've definitely seen a lot of scheduling of interviews in Guangzhou. So I think that is what's happening here. So that's very promising. And we hope the Department of State will continue to schedule these interviews. You know, the bigger issue that we're seeing right now, and I am going to jump a couple slides ahead here, is that the Department of State is not issuing any reserve visas. We asked them specifically as part of AILA and our Department of State liaison, and you can see it here, and what their response is. And they indicated that in fiscal year of 2024, they issued 4 reserve visa numbers. 4. They didn't issue any in fiscal year 23 or any in fiscal year 2022. So in the 3 years since these reserve visa categories have been created. The Department of State has issued 4 of them, even though there are a number of approved I-526Es registered at NVC ready to go. Why aren't they scheduling those? We don't know. It makes no sense, and it's something that the Department of State needs to improve on. And that's what we are pushing them to do through these informal liaison is, we're trying to tell them, hey, look, this is a big problem here. Now, this doesn't account for any reserve visa numbers that could be used by USCIS when you are doing an adjustment of status. And we have seen more than 4 adjustment of status approvals based on reserve visa EB-5 investments. So, I don't know how many, certainly not the thousands that are available in fiscal year 2024. I think we're talking more about hundreds, maybe even, but not enough to make a big dent in that number, which is why it remains high again in fiscal year 2025, because there were all of those rollovers from last year. So I don't know, it's peculiar to me. I guess, Charlie, my question to you here is, there's no real reason why the fact that they're in a reserve visa category, that shouldn't stop the Department of State or consulates from scheduling these interviews if they have all other aspects completed for the issuance of the visa, right? I mean, it seems like this is a policy issue more than a consulate scheduling, or I don't know. It seems off to me, and I'm trying to understand why the Department of State hasn't done this yet.
It is somewhat disconcerting, given the fact that we're 2.5 years into the program, and as you mentioned, the state has issued 4. All of the cases, as they become documentarily qualified and are reported to the visa office, they should be being scheduled for interview. So if the state is taking an active stance of withholding the scheduling of interviews, this is a somewhat disturbing situation. Again, the National Visa Center will report to the visa office by the beginning of each month all of the applicants who have become documentarily qualified since the last report was submitted. Those applicants that were reported on that or any earlier report are considered for scheduling. And anybody that's on that report and is within the applicable final action date should be scheduled for the upcoming month, regardless of the visa category. There are certain times when post-processing capacity could limit that, but at most it should be a 1-month delay. So again, this is a little bit disconcerting that they've taken this stance, if that's in fact what they are doing.
Right, but consulates also have some discretion in terms of the types of cases that they can schedule for interview, don't they?
They could, but again, there should be reasons, and they should not actively withhold. If it's possible if they were unable to do, say, the reserve this month, then they should catch up and make it up the following month. It should not be a blanket thing saying we're not going to do any reserve numbers unless they do not have the officers that feel comfortable processing such cases. They don't have the expertise. These EB-5 cases are a little bit more complicated than your average case, but again, the officer should be able to do them. So as we see more cases approved, one of the key things would be if we could kind of figure out how many people are reporting themselves to the National Visa Center and have submitted all the documents. It's very possible that maybe just not sufficient amount of applicants have submitted all of the required documents to allow them to be scheduled for interview. And that's why it's very important for applicants to work in a timely manner to submit all of their documents as quickly as possible.
And I'm trying to think, we should be getting a report from NVC. They always issue that report saying, as of November of this year, X number of cases have been deemed documentarily qualified. Is that right? Has it been documentarily qualified in each one of these visa categories?
It's a waiting list of the applicants who have petitions on file at the National Visa Center as of November 1st of each calendar year. So the National Visa Center will run that report, submit it to the State Department Visa Office for them to assemble the data. Typically, that report is then published sometime in the middle to late December. This past year's report reflecting the demand as of November of 2023. I think it was delayed until about March. That's really, really totally unacceptable. I'm sorry to criticize, but the data would have been provided by the National Visa Center probably no later than November 15th. It is a kind of a time-consuming report to assemble, but again, in my day, it would typically be released no later than the middle to late December. But it will list all of the applicants with reserve petitions on file at the National Visa Center.
Well, that's what I'm hopeful is that you made a mention of this in an email, is that they should break it down based on the reserved visa categories in that report, which they haven't done in years past.
Correct. The reason they didn't do it before is they probably didn't have the cases. It is a very useful report to look at, and it breaks down demand by each of the family and employment categories. So it will reflect the amount of reserved visas that are on file there at NVC. And that will be kind of a telltale sign whether, yes, appointments should have been being scheduled, or no, they just didn't have enough cases to be scheduling. And that may very well be the case, but I kind of doubt it.
Well, I know you said you don't like to criticize, but I have no problem doing it. And something at the Department of State smells fishy to me with the number of I-526Es that we have approved and the few number of reserve visas that were actually issued last year.
Yeah.
Something's fishy to me, and I'm sure we'll find out more information in the future. But in the meantime, I think it's potentially becoming, I don't want to say less of an issue because it's important, but we are seeing so much demand from within inside the United States is that a lot of EB-5 applicants aren't even dealing with the Department of State anymore. It's all being done with USCIS and this new concurrent adjustment opportunity that was created, what allows you to file an adjustment of status at the same time that you file the EB-5 petition, because a visa is available and the visa bulletin says current for all countries for all of the reserved visa categories. And that is a huge, huge benefit that allows you to get your unrestricted employment authorization, your ability to travel internationally during the time in which the adjustment of status application is pending, including if there is retrogression in the future, which there will be, in particular, much more likely to occur quicker for high unemployment area than for rural, which we're going to talk about in a moment. But that is a huge benefit. And, people have called it a game changer. And it's just, you get to start the green card process much quicker now than you would have previously, where you would have before needed to wait for your I-526 to be approved to file the adjustment. This is why a large majority of my current EB-5 investors are here in the United States on H-1B, stuck in EB-2, EB-3 visa backlogs, see children aging out, see layoffs, or just want sort of to have a little bit more of a peace of mind and perhaps more proactive immigration journey, as opposed to just waiting for their priority date to become current, if it will at all, because of these crazy demands and the limited supply from the per country caps in those categories. And we're going to be talking about per country caps in just a moment. But before I do that, I just wanted to plug, this has become such an important topic, and I get questions on this every day, multiple times, and there are a lot of nuances to this. When can you file, or when should you use your EAD? What happens if you leave before getting your advanced parole? How do you come back in and maintain your non-immigrant status later on? There are a lot of nuances to this and a lot of questions from people who want to make sure that when they're doing this EB-5 process, they are not messing themselves up or precluding them from other options in the future in the event EB-5 doesn't succeed. And so we are doing a webinar on this. We will be putting a link up here, and it'll be with our managing partner, Bernie Wolfstorff, who's been practicing immigration law for 4 decades and is considered a top thought leader in the immigration bar. And it'll be he and I, and we're going to be talking about what that may mean for specifically EB-5 applicants, what happens if a 956F is denied, what that means for your 526, what that means if you've used your EAD, all of those kind of very fact-specific scenarios. We're going to be getting into the nitty-gritty there, and we hope you will join us for that. I will say something that is common, and I wanted to get this point out now, is you have probably heard that Congress has indicated that they want USCIS to prioritize the processing of applications associated with rural investments. I want to say that really, in practice, we have only seen that to date with regards to 956Fs, which is a regional center application, and the I-526E, which is the EB-5 application. It is not impacting the timing for an EAD or for an advanced parole. That is done separately through a different USCIS office that you get as a matter of right because you have filed an adjustment of status application. And that is not, we're not seeing big changes on timing and processing with that because somebody goes with the rural or somebody goes with high unemployment. Yes, we are seeing those getting longer. Earlier this year, I was saying, yeah, we're seeing them in as close as 3 to 4 months. That's not happening anymore. We have a number of clients who filed in March before the filing fee increase of 2024, and 7 months later, they still haven't gotten their EAD. So it is getting longer. That is frustrating, but you want to get your spot in the line for both the EAD and your priority date, and you do that by making your investment and getting your application in. So we're going to be talking a lot more about that at our webinar. I just wanted to plug it now, and we'll be sending out a blog and giving you more details on that. All right, so the next thing I kind of wanted to get into, and this is sort of our last portion for today, is the demand and the supply for the different reserved visa categories. And there are some assumptions here that are built in that we are going to go through. We're not going to be talking about, well, when is a final action date going to be imposed? Stay tuned for next month's Chatting with Charlie when we're going to be getting into that. But today, right now, we're just going to be kind of talking about the concepts behind why a final action date may be imposed in the future and what, the Department of State and someone who's in Charlie's past position will be looking at. And so here we have 3 vertical lines. The first one, that's based on data that was received through FOIA, I believe. They were saying that over 2,200 rural reserved I-526s have been approved. Assuming all of those get approved, and assuming there are 2.5 applicants, either adjustment or consular immigrant visa applicants per I-526, then based on the demand or the number of filings that we have, there's over 5,700 total demand for those visas. And when we look at that third column, we see the total supply of rural reserve visas through the end of fiscal year 2024. And that is estimated based on certain worldwide annual allocations and uses of visa numbers. So again, these are estimated, but what you can see very plainly when you look at rural versus high unemployment, which I'm going to pull up here, is that you can kind of see that middle line is much bigger for high unemployment than it is for rural. And that third line, the gray line, is bigger for rural than it is for high unemployment. And I think this chart is very good to understand, in particular for Chinese and Indian nationals, why you're more likely to see a final action date imposed for high unemployment area projects than for rural projects. And then we also have this last slide for infrastructure. And to date, I don't really know of any I-526Es that have been filed for infrastructure, but there are those as well, which we wanted to point out. So I just spoke a lot. I'm going to give Charlie a chance to to speak about this and maybe answer some of these questions. Like, there are per country caps for each one of these reserve categories. How does this look for, in terms of rest of world demand and what that means for, use of these numbers for China and Indian, which could be subject to that per country cap?
Yeah, I think on this first rural chart, it shows, the amount of petitions filed and total applicants to date versus the amount of numbers available through the end of fiscal 2027, there are far fewer applicants than there are numbers, meaning this suggests the category can and will remain current for the foreseeable future. And by that, I mean at least until the summer, if not for entire fiscal 2025. So this is a very good sign for those that have filed in the rural. In this chart, for the high unemployment, there are already approximately twice as many applicants as there are numbers available. So this chart shows that it is guaranteed that there will be final action dates on a rest of world basis, a China basis, and an India basis at some point in the future. And that would be dependent, when those dates would be applied, is completely dependent on how quickly the State Department and USCIS begins to adjudicate these cases at a much faster pace. We haven't seen that now. And again, the slow processing during fiscal 2025 lends itself to the categories remaining current through the fiscal year. But I think that there is much more likelihood of a date being imposed for high unemployment than there will be for the rural category.
Let's just say miraculously Department of State does speed up their issuance and USCIS does speed up their issuance. How does the use of those numbers this fiscal year help people in the future?
Well, it is very important, and that's one of the reasons why it's kind of disconcerting that they haven't been processing, because we want to use the reserved numbers which were not used in fiscal 2024 are added to the 2025 annual limit. Those numbers only carry over for 1 year, at the end of which they would be added to the unreserved category. And those carryover numbers from fiscal 2024 will be used first for processing. So it is extremely important for the maximum amount of those numbers to be used this year, therefore reducing the amount of applicants requiring the use of numbers next year with applicants that have very early priority dates. So we need really the State Department and USCIS to maximize the reserve number use this year to pretty much alleviate the growing wait list of cases and the impact it will have on the final action dates. There will definitely be final action dates for the high unemployment and rural categories in fiscal 2026. But to the extent that cases can be processed this year, it will mitigate those final action dates in 2026.
Thank you. That's a really helpful answer. And I think maybe just conceptually, what we're trying to say here is we see kind of this waterfall going to the upward right direction on the fiscal year. And the thought is that you only want the waterfall to go over for 1 year and not for a second year. And what we've seen that to date is that those 6,400 or so reserve visa numbers from fiscal year 2022, they were used last year in the unreserved visa category. And that's what we're talking about in terms of wanting that quicker processing before they carry over and no longer can be used in the reserved category.
The fact that the reserved numbers have not been used has allowed the old unreserved cases to be processed, but that's happening at the detriment of the reserved visa applicants. And again, this is kind of what happened in the original EB-5 program when petitions were not being approved in a timely manner and cases were not being processed, and a large backlog of waiting list cases developed so that when they finally did start processing cases, it very quickly required the imposition of a final action date for China. And that was an early date because they had to address the petitions filed early. Unfortunately, we're going to see the same thing happen here in the reserved categories, and it is a very unfortunate situation.
Well, I think it's important for people to know that these final action dates for high unemployment area investments are coming. They're also coming for rural at some point in the future. It's basic demand versus supply. And the big benefit of doing EB-5 while you're doing the concurrent is that even if there is that final action date or retrogression and you're no longer maintaining your non-immigrant status or it expires or whatever that it's terminated, you could still remain in the United States. And if you're stuck in a backlog, but you're able to be here and you're able to work here lawfully, there are worse things. And it's still something that a lot of people are going to be choosing to do. The last thing that I kind of just wanted to bring up, and we're going to put a link up here, is, when we talk about EB-5 project selection, it is a multifaceted decision. It impacts so many different areas, not just financial and family and immigration, but also tax and estate planning. And there's a lot of items that need to be considered when you're doing EB-5. JTC is a group that does a lot of fund administration and escrow banking in the EB-5 world. And they just put out this great white paper in conjunction with a regional center called Pan-Am. And they asked me to write, and it's a great white paper about EB-5 project due diligence. I think it is worthwhile to read. It's a 5-10 minute read, but it really gives a good, detailed, quick understanding about the type of due diligence that any EB-5 investor should be performing when they're looking at the EB-5 projects. And it's not like promotional or anything like that. It's really, really good and clear considerations that everybody should be thinking about. So if you have any questions, you can always reach out to us. Charlie, thank you so much for coming on. I asked you last year, I'm going to ask you again. You got a Halloween costume?
Captain Hook.
Hey, I'm going as a pirate too.
The grandchildren are big into Peter Pan, and so they asked me to be Captain Hook.
Amazing. Well, you're going to have to send us a picture, and I'm going to post on LinkedIn and make sure everybody in your professional community sees that. Well, thank you, Charlie. Appreciate all of your insight.
All right.
Thank you, everyone, for joining.